Hugo Grotius. Part 1. War, Contract and Law. To go from Johannes Althusius to Hugo Grotius is in many ways to step backwards in time, to find oneself, politically speaking, in the company of Luther and Calvin. If Althusius can be pedantic and repetitious, Grotius is ponderously prolix. Both writers are prone to stuff their works with supporting citations from classical and contemporary authorities, but in any fairly judged contest, Grotius would surely be the winner by a country mile. The work for which Grotius is best known, The Rights of War and Peace, comes in at a mentally and physically hernia-inducing 1900 pages. So much for matters of style. What of the substance? Here, matters are better, but not universally so. Grotius is confused and confusing on the topic of law, the key concept in this work, and on the subject of sovereignty. His views are regressive. It is not often that I find myself in sympathy with Jean-Jacques Rousseau, but with his judgment on Grotius in Emile, minus its hardness and jealousy, I can find myself in tune. Grotius, he writes, the master of all the savants in this subject, is only a child, and what is worse, a dishonest child. When I hear Grotius praised to the skies, and Hobbes covered with execration, I see how far sensible men read and understand these two authors. If Grotius is a poor writer and a confused thinker, why then does he occupy the position he does in the history of thought? The answer to this question might be that he is famous because he was the inventor or discoverer of the idea of international law. But in fact he wasn't. Much of the work which Grotius gets the credit for originating was done by the Spanish jurists before he was ever wrote. With the utmost charity in his heart, William Dunning writes, without detracting from the just fame of Grotius, it is necessary for the careful student to point out the currents that were manifesting themselves in various philosophical channels before he wrote, and that set straight toward the system which he presented. But the work of the Spanish jurists was Catholic and scholastic, and on these two counts unacceptable to a northern European culture that was increasingly Protestant and humanistic. On the other hand, there were Protestant writers such as Oldendorp, Hemming, and Winkler, who developed theories of law that dovetailed smoothly with the work of their Catholic Spanish contemporaries, but which failed to have the effect that Grotius was to have, perhaps because their work was more Protestant than humanistic. Taking everything into account, I think it can fairly be said that Grotius's major accomplishment was that, if he wasn't the first, he was certainly the most influential thinker to reapply the venerable notion of natural law to the newly emerging field of interstate relations. Whatever the just solution to this conundrum, Grotius was the right man at the right time, in the right place, with the right approach. He was a child prodigy, skilled from the earliest age in mathematics, in literature, jurisprudence and philosophy. At the age of 33, he became, in effect, the principal civil servant for Holland and West Friesland. He took sides in the violently polemical religious, political and economic disputes raging throughout this region and found himself on the losing side, as a result of which he was sentenced to life imprisonment. He escaped to France, and it was here that he produced the work that was to bring him universal renown, The Rights of War and Peace. In time, he became surplus to requirements in France and emigrated to Sweden, only to return eventually as the Swedish ambassador to France. Oh, the ironies of fate. The Rights of War and Peace is very much wider in its scope than its title might immediately suggest. It is in fact a treatise on the law of nature and the law of nations. In the classic debate between physis and nomos, between nature and convention, Grotius, for the most part, takes the side of nature. Man is naturally both rational and social. Grotius is willing to accept the skeptical position that men associate with each other, driven by a natural desire for self-preservation. But this is only part of the story, and not the most interesting part. The natural desire for self-preservation is not the only natural desire we have. we also desire by nature to live life in association with others, and in so doing, we recognize the good of justice. Justice, then, is not merely conventional, but a necessary constitutive part of social life, such a social life being intrinsic to the good for man. The time at which Grotius wrote The Rights of War and Peace was the time at which it was becoming evident that the religious and political divisions of European Christendom were here to stay, and perhaps more significantly, that the ever more highly centralized post-medieval sovereign states were also here to stay. The practical question arose, how were these sovereign and independent states to relate to one another lawfully when they acknowledged no common superior? The most spectacular way in which one state can relate to another is through the violence of war, a condition of which Grotius had first-hand experience. Grotius is, of course, best known for his analysis of this particular aspect of interstate relations, namely the question of whether and in what circumstances violent action, war, may be justified. Well then, can there be just wars? Grotius answers yes. Defensive wars to protect persons and property against aggression are clearly just. Offensive wars may be just if they are waged to prosecute injuries or to inflict punishment which is deserved, such being the case when contracts or promises are violated. Defensive and offensive wars are both bilateral affairs involving a putative injured party and an alleged aggressor. However, Grotius does allow for third-party interventions, where the intervening agent is not directly the object of any injury. Once again, relying on classical precedents, Grotius here believes that rulers have a duty to enforce the law of nature, and, if that is being violated by the rulers of another state, intervention is justified. Whether such intervention is expedient or not, of course, is another question. This is a particular instance of the limitations of sovereignty as Grotius sees it. Sovereignty does not absolve rulers from adhering to the law of nature as it absolves them from submission to positive law. On this issue of third-party intervention, Grotius finds himself in opposition to those such as Francisco Vitoria, who hold that force or violence is justifiable only if exercised by those who have been aggressed against, or their agents, or by those who have jurisdiction over those who are aggressed. He writes, "We must also know that kings and those who are invested with a power equal to that of kings have a right to exact punishments, not only for injuries committed against themselves or their subjects, but likewise for those which do not peculiarly concern them, but which are in any persons whatsoever grievous violations of the law of nature or nations. For the liberty of consulting the benefit of human society by punishments, which at first, as we have said, was in every particular person, does not, since civil societies and courts of justice have been instituted, reside in those who are possessed of the supreme power. Nay, it is so much more honourable to revenge other people's injuries rather than their own." But war is only one aspect of interstate relations, even if it is the most spectacular and destructive of them. Grotius's interest extended beyond the issue of war and peace to trying to find a basis for universal legal rules in a reconsideration and reconceptualization of the venerable notions of jus naturale and jus gentium. Grotius's most important contribution, then, was not so much to an intrastate analysis in matters such as, for example, sovereignty, but to an analysis of the relationships between the now sovereign states, each free from the legal control of the other. With the collapse of a common Christendom, however tenuous it may have been, and the increasing irrelevance of the empire, the question of the relationship to one another of the new autonomous states became urgent. Without a common superior, it would appear that their mutual relations would have to be conducted outside the sphere of law, subject only to considerations of expedience and power. The rise of the absolute monarchies and the more or less frank acceptance of a Machiavellian conception of the relations between them made force the arbiter in the dealings of states with states, writes Sabine. To this must be added the effects of the religious wars which followed the Reformation, bringing to international relations the intrinsic bitterness of religious hatred, and affording the colour of good conscience to the most barefaced schemes of dynastic aggrandizement. If there was to be a source of norms that could govern interstate relations, then it would have to be found where all could accept it, despite their particular differences of language, culture, and religion. That being so, it is scarcely surprising that Grotius turned to the venerable idea of the natural law, this time shorn of any essential connection to religious revelation, a naturalized natural law, as it were. Of course, the idea of natural law is not acceptable to everyone, so Grotius chooses to confront the skeptical challenge as expressed by Carneades, the critic of Stoicism. For the skeptics, human action is governed by self-interest, and law is merely a conventional social apparatus whose primary justification is a matter of prudence rather than one of justice. Grotius's response to this criticism is to point out that human society results not just from prudential considerations, but from an inherent sociableness, although utility plays a supplementary role. Human nature itself is the mother of natural law, as it drives us to seek a common society, even if there is no shortage of resources, he writes. But utility is annexed to the natural law. The author of Nature willed that as individuals we should be weak and in need of many things, if we are to lead a good life, in order that we should be all the more impelled into living in society. In the Prolegomena to the Rights of War and Peace, Grotius distinguishes between two possible impulses to social cooperation: a natural inclination towards sociability and an association based on agreement in the service of self-interest. Sometimes he seems to favour one account and sometimes the other. Do human beings come together in society because they have determined that it is in their interest so to do, or do they congregate because they have a natural desire to live with others of their kind? Grotius believes that human beings lived in society simply because that is how they are constructed, whether such cohabitation is in their interest or not. As it turns out, cohabitation is productive of utilitarian advantages to all. But that is a happy accident. The appearance of confusion here may once again be the result of a failure clearly to draw a distinction that Grotius flirts with, a distinction between society on the one hand and the state on the other. Using this distinction, society would be the outcome of a natural human propensity towards sociability, while the state would be the outcome of an explicit contract or agreement. Men did not at first unite themselves in civil society by any special command from God, but of their own free will, out of a sense of the inability of separate families to repel violence. As a rationalist, Grotius has confidence in the power of human reason to hit upon the principles of conduct that will be conducive to the needs of human social existence. Whatever the ultimate justification of their theories of natural law grounded upon a universal reason was going to be, the thinkers of this early modern period, Grotius included, tended to take for granted that the bindingness of an obligation upon an agent derived from that agent's free assumption of that obligation. The moral force of an obligation derives from an inward normative necessity, not merely from an outward threat of sanction. The relevance of this to the matter of political obligation was that it undermined the idea that such obligation could be legitimately imposed without the consent of those on whom it was to be imposed. This idea, the idea of a contract or a compact, was to play a prominent role in political thought from this time forward. It is true, as we have seen, that the germ of such an idea was already present in the thought of the High Middle Ages. However, it comes into renewed prominence during this period, a prominence which, despite much criticism, it has never quite lost since. The dominant political treatise of the last third of the 20th century, John Rawls' A Theory of Justice, is merely the latest in a long line of contract theories. Most thinkers take what they have to explain to be the transition from individuals in a pre-contractual state of nature to the post-contractual social or political order. Grotius, however, realize that it is not only the case that individuals can be conceived to be in a state of nature vis-a-vis one another, but that the states resulting from the contract among individuals could themselves be conceived to be in a state of nature in respect of each other, and so be in a position to contract with one another. There are different ways to conceive of these contractual relations. Members of a set of people can contract with each other in a series of independent, mutual horizontal relationships. On the other hand, a set of people can agree jointly to organize a group and set it up with a constitution so that they jointly form a kind of corporation of which each individual contractor is a member. It goes without saying that different writers conceived of the contract or contracts in different ways. As we shall see, Hobbes recognized only the horizontal contract that brought the ruler into being. The ruler was not party to the contract, and his sovereignty was not conditional upon performance. Locke's account of contract is ambiguous. You may remember that Althusius was of a mind to conceive of two contracts, one horizontal, by which a people agreed among itself to bind themselves together, and the second vertical, by which this now bound together corporate body contracted with its ruler or rulers. A theory of contract, just as such, is indifferent in the matter of the political character of the state. Whereas Hobbes and Spinoza had it give rise to a form of unlimited absolutism, Locke and Althusius had it give rise to a form of limited power. Grotius emphasized the moral limits that circumscribed rulers without full-bloodedly justifying revolution or resistance. There are, broadly, two ways in which one can think about the relationship between man and society. One can start with society and take as one's problem the task of finding space within that society for the individual. This is the general trend of classical thought. The modern approach is to start with the individual, and then the problem becomes one of justifying or explaining society. The individual is both logically and ethically prior, writes Sabine. To the philosophy of the 17th century, relations always appeared thinner than substances. Man was the substance, society the relation. It was this assumed priority of the individual which became the most marked and the most persistent quality of the theory of natural law, and the clearest differentia of the modern from the medieval theory. For Grotius, those acts are right, jus or just, which are not fundamentally destructive of man's life in society, destructive of the essential order which every society requires. Theft, for example, destroys trust, and so cannot be just. One can see the libertarian non-aggression principle assimilating itself to Grotius's notion of justice. Still more libertarian vistas appear when we come to Grotius's second notion of right, jus, which is the right to do and to have, to act and to possess. This looks like an anticipation of the modern subjective notion of right that belongs to man as man, rather than man as defined by status or property relations. This is perhaps to go further than Grotius was prepared to go, though an unambiguous subjective account of right would appear in the work of Thomas Hobbes. And of course right, jus, has the standard meaning of law. Jus, or right as law, is divided by Grotius in the following way, which indicates clearly his understanding of the often vexed relationship between the jus naturale, natural law, and the jus gentium, a law of nations. The first division is between the jus naturale, natural law, which is an emanation of reason, and volitional law, which, as the name suggests, is a creature of the will. Volitional law is of two kinds, human or divine, depending on whether the will in question is human or divine. Divine law is given to us through revelation. Human law has three kinds. The first is non-civil law, which might be described as the commands issuing from those forms of authority that are natural, such as those of the father in the family. The second is the standard civil or municipal law, regulating human affairs within a particular jurisdiction. And the third is the jus gentium, which derives from the will of all or from the will of many people. Before we get to a more detailed treatment of the various forms of law, let's broadly consider the relation between the jus naturale and the jus gentium. The jus naturale is grounded on reason, while the jus gentium is based on will. Their subject matter may well coincide, at least in part, but whereas the jus gentium is changeable, the jus naturale is not. Moreover, the jus gentium belongs on the volitional side of the Great Divide, attaches to only one part of the basic division within volitional law, and is still only one of the three parts of that division. Grotius offers an example, not perhaps perfectly perspicuous, to illustrate the difference between the two types of law. By the law of nature, he thinks, one person cannot be made responsible for the debts or obligations of another. However, by the law of nations, citizens are responsible for the debts and obligations of their rulers. While Grotius held that no man is a slave by nature, he conceded that slavery can be voluntarily entered into or inflicted for wrongdoing, and slavery that arises in this way is in accord with the natural law. The enslavement of war captives is, however, a matter of the jus gentium, and is not something of which Grotius is particularly enamoured. What Grotius is groping towards here would seem to be a distinction between legal rights and moral rights, so that the enslavement of war captives would be legally in order, but morally reprehensible. However, he has but one word at his disposal, jus, and so there is a constant tendency in his thinking towards the conflation of the legal and the moral orders.